Hi, everybody. Welcome this year to CBOR's Con Ed. My name is Gregg Nathanson. It's really great to see everybody. You guys look terrific. It's wonderful. Is this live this year? Well, even if it's not, it's still great to see you all. I'm going to talk about two cases. They both deal with broker commission disputes. And the good thing about these cases is there's good legal hygiene and risk management lessons in here for you that should help you secure payment of your commissions as long as you do what you're supposed to do and you have the right paperwork in place. So let's take a look at these cases. The first case is out of Tennessee. And here's what happened. The broker listed church property for sale, sold for $10.2 million. So the broker received their 6% commission, which is probably an average payday for most of you. And then the church asked the broker, can you find us another property? We're looking, obviously to move. At first, they said, look at what's listed. And the broker said, fine, I don't really need a contract with them because I'll get paid derivatively through the listing agent. And then the broker said, can you expand the search a little bit? I'm sorry, the church did, and said, can you take a look for properties that aren't listed? So the broker thought, well, I should really get something in writing. So the broker had the church sign an exclusive buyer's broker agreement that said the church would pay the broker 4% if the church enters into a purchase agreement within 1 year. And there was also a protection period or a carryover period that said the church would pay the broker the same 4% if during the 6 months after the agreement expired, the church signs a purchase agreement for a property that the broker introduced. So the broker president, Eric Boozer, and you can't make this stuff up. The guy's name is Boozer. So he drafted this agreement. What he did, and this is something none of you should do, he took the listing agreement and he changed the name seller to buyer, and he had the church sign that. So probably some of you are thinking, well, I can see where this is going. Well, Boozer, and they didn't say whether Boozer was on the sauce or not at the time, but he messed up. What he meant to say is if the church buys a property from a seller where the property has been shown or introduced to the church through the broker, then the church gets paid. Now, because he just swapped the terms, purchaser and seller, it said, should the church contract to purchase property that was shown to a seller? Now, it doesn't make sense. You don't show a seller their own property. And if you do, what good does that do the church? So Boozer and the church president, Perez, had exchanged emails. It was pretty clear from the email chain that the intent was for the church to pay the broker the 4% if the property was found. So another interesting fact, before the buyer agency agreement was signed, Perez was driving around. It was a nice Sunday afternoon. He sees a church building that wasn't listed. He stops, he looks at it, he walks around, he takes pictures, gets in his car and drives away. Then after that, he signed the listing agreement. So Boozer got active. Boozer sent him information on some properties, including this church property, which was on Park Avenue. So it's probably a nice property being on Park Avenue. Boozer then accompanied Perez for an on-site visit of the Park Avenue property. They took a look at it. And Park Avenue was later listed for sale. And then during the 1-year listing period, the broker had shown the church over 100 properties, negotiated several written offers, never came to an agreement, and then the listing period expired. Now, I wonder how many of you have had that feeling, where you're working yourself, you're running around, you're doing everything, and then the listing expires, wasn't extended. Well, so what happened? The church turned to one of its parishioners, Mr. Holland. Mr. Holland negotiated the purchase of Park Avenue. The deal closed. And this was after the 1-year listing period expired, but during the 6-month carryover. So the church bought it for $1,980,000. They paid the commission to Hollander, but not the broker. So what happened? The broker sued. Said, well, wait a minute, under the doctrine of mutual mistake, you have to pay us. what did the church say? The church said, well, wait a minute. First of all, the agreement doesn't make sense. It's gibberish. You are a licensed professional. You drafted this agreement. You should be responsible if it doesn't read properly. And then the church said, beside, even if that was our deal, we found the property first before we signed our exclusive buyer agency contract. So you didn't show it to us first. You didn't introduce it to us. You don't deserve anything. Okay, what did the court say? The court first said, yeah, this contract, Boozer, what kind of language is this? It didn't make sense. So the court can reform a contract. In other words, what they can do is take the language and make it read how the parties intended for it to read if the language was poor as a result of a mutual mistake or fact. So here, the court said you have three criteria. The first, did the parties reach an agreement? And it's like, yes, they did, because the church agreed to pay a commission to the broker for finding the property. Second, did the parties intend to include that agreement? And yes, what Boozer meant to say but left out was whose property has been introduced or shown to the church. Seems like a pretty important phrase, but it was left out. And then the third point is there variation between what the parties agreed and what the contract says due to gross negligence? So what the court ended up finding out is Boozer was negligent, but not grossly negligent. So grossly negligent is a higher standard. It's more like being reckless. So the next question is, normally there's a rule in construction of contracts that say you can't look beyond the four corners of the agreement. And that was in the olden days when contracts actually used to have four corners. Now they're more electronic. And to be able to look beyond the four corners, it's called the parole evidence rule, saying you can't. Now, parole doesn't mean that Boozer was doing time and he was out on parole. What it means is, can you look at extrinsic evidence outside the contract to show there was mutual mistake? And the court said, yes, you can do that here. So then they reformed the contract to say what Boozer wanted it to say, because that was what the parties really intended. So the next question is, assuming that's what the contract says, because that's what the court is saying, did the church breach the contract? And the church said, well, the broker didn't introduce us to Park Avenue property since we found it on our own first before the buyer agency agreement, which is true. So what the court decided is they took out their dictionary, or really they looked online to look at their Merriam-Webster dictionary, and introduce means present for the first time or to put forward for consideration. So the church said the broker introduced Park Avenue to the church because the broker presented the property to the church for consideration, even though Perez was already aware of it. So, and they were entitled to their 4% commission. So the lesson here is the broker did recover, but they were lucky. I mean, it could have depended on the judge, could have depended on the attorneys. And your takeaway here is you have control over the contract you prepare and the contract that you have signed. So you should make sure that you have a strong contract that says what you want and you get it signed at the appropriate time, because if you do that, there's a lot less to argue about. Not saying people can't come up with things, but there's a lot less to argue about. So through that strong legal hygiene and good risk management, you'll be doing yourself a favor. Okay, next case was a Michigan case. Both these cases, by the way, were decided this year. Here's what happened. A buyer saw a house they liked. They went to a buyer's broker and said, hey, can you negotiate a purchase agreement on my behalf? Broker says, of course, love to do it. So the buyer and seller sign a purchase agreement, $440,000, which is probably on the lower end for the houses that most of you have, with a 2.5% commission. It was contingent on the buyer closing on the sale of their current home, closed by July 8th. And it had a time of the essence clause in there. You know, that's part of the boilerplate at the end of the contract that no one ever reads or understands or wonders why it's even in there. There's a time of the essence clause. And the contract identified the broker as the selling agent who's going to earn a commission here. So closing didn't occur by July 8th. What do you think happened? Well, July 9th, the buyer goes to the seller's house. They're taking measurements for furniture. The seller says, here, have some coffee. I have this coffee cake. Have a slice. Enjoy yourself. They're getting along wonderfully. So the broker walks up to the seller and says, hey, would you just sign this amendment to the purchase agreement? Let's just extend the closing date and make it formal. And the seller gets this Cheshire cat grin on his face and says, well, kind of folds his arm and says, I want to keep my options open. I mean, how many of you have had that sinking feeling? Like you know where this is going. So 2 days later, the seller contacts the buyer, says, psst, buyer, are you there? Yep, I hear you. I have an idea. Let's sign a new contract. Same as the other one, okay? Same purchase price, same everything, close August 1, except we're going to exclude the broker. Okay, we're going to eliminate the broker getting paid a commission. The buyer says, do you mean you want to throw the broker under the bus and not pay him even though he's performed? The seller says, that's exactly what I'm saying. Buyer says, okay, I'm in. So that's what happened. The buyer, had later said, I didn't want my family to be stuck living in their RV forever. Again, that's what it is in life, right? So the buyer and the seller sign a second purchase agreement. Same price, same everything, closed by August 1, didn't mention the broker. August 1, the broker files their lawsuit under the first contract, breach of contract, and unjust enrichment because they provided services to the seller for which they were not getting compensated. Interesting here, because it was a residential broker and not a commercial broker, they couldn't record a commercial real estate broker lien. And I've had a number of clients that have been very successful recording their liens, and it either gets them paid or it gets them substantially paid. So it's a very powerful tool that they didn't have, but obviously it's one you should be prepared to use if necessary. So a sale closed on August 15th. Of course, there was no written extension of the August 1 closing date, so I guess time wasn't of the essence there. Trial court looked at it and said, this broker, you get your commission. You clearly earned it. And through the seller's course of conduct, they waived the enforceability of time of the essence. In other words, the waiver wasn't in writing, but the waiver was through their behavior, the coffee cake and all that. It was clear they wanted to give the buyer extra time. So what happens? The Court of Appeals reverses. What they say is the first purchase agreement said closed by July 8th, which didn't happen. It said time was of the essence. There was no written extension, therefore terminated. And the seller's conduct, well, okay, the seller did do a couple of things suggesting that they wanted the deal to go forward. You could say like by signing an identical purchase agreement, but the court said it wasn't established by clear and convincing evidence. So court said, statute of frauds, the agreement to pay a commission, sale of real estate has to be in assigned writing. And the first purchase agreement granted it, but what the court said was, second purchase agreement didn't grant a commission and it superseded the first. So by signing the second agreement, the first agreement became null and void and the broker could no longer rely on it. So there was a problem for the broker. The broker said, well, what about unjust enrichment? I brought the buyer to the table. The seller has benefited. The court said, statute of frauds, can't do it. You need assigned writing. And finally, the broker said, well, there's this doctrine called part performance, which takes you out of the statute of frauds if the seller makes a promise and you rely on that promise to your detriment and the seller benefits. And the court said, no oral promise. All we see is that written promise in the first purchase agreement, which is null and void. So, and I don't know if this is going to go up to the Michigan Supreme Court or not. But again, the moral of the story here is had the buyer's broker, had the buyer sign something saying, we'll do our best to get the seller to pay my commission, but if they don't, you're on the hook, then this probably would have played out a little differently, and the buyer would have stood their ground a little more firmly. So again, what it gets back to is good legal hygiene, good risk management, and having good solid contracts that are going to protect you in the event that things go sideways. So if you have any questions in the future, contact me. Please reach out. I'm always happy to help in any way that I can. And that really concludes what I have to say in my warm-up act. And the featured speaker today is really Enrico Schaefer. And he's a technology and intellectual property lawyer handling complex business matters and litigation. Enrico teaches Part 107 study classes for the Interdrone Conference, is a partner with the UAS program at Northwestern Michigan College, is vice chair of the CompTIA Drone Advisory Council, and is a frequent lecturer on business and compliance issues facing Part 107 service providers. Enrico can be found at www.dronelaw.pro and runs the podcast Drone Law Pro Radio. So Enrico is outstanding. You're going to learn a lot. You're going to love it. So let's just have this drone talk take off, and I'll turn it over to Enrico. And thank you again for your time and attention.
Thanks, Greg. Appreciate the opportunity to be here, and welcome to all of you. And of course, drones are always interesting topics. People are interested in drones. Drones are not going away. Within the real estate game, drones have really been part of that game since drones first came on the scene, because there's such an obvious use case for drones and real estate. And so we've been working in the space of real estate drones since about 2013, 2014, before the Federal Aviation Association, the FAA came up with the Part 107 rules for commercial drone operators. So real estate and drones go together hand in glove. They're going to go together for a long time, because you just can't replicate the photography and videography you can get with a drone for your listing. So today I've got a couple of different bullet points that we're going to dive into, and let me just review them pretty quickly here. We're going to talk a little bit about what you need to know about the drone regulations, laws, and legal issues, why you should care if your drone operator, your pilot that's getting the photography and videography is FAA compliant. We're going to talk a little bit about liability issues such as trespass, nuisance, privacy, and other state laws that could apply to the drone operation over your client's property. We're going to talk about key contract provisions that real estate agents and brokerages should always include in every drone service agreement when you hire the drone pilot and service provider. You're going to want a written contract, and you're going to want it to contain certain things. You're going to have to understand copyright law, because you're either getting a license or an assignment to the photographs and videos that are being captured by the drone. You need to understand that license, the scope of the license. Talk about penalties for infringement of copyright, which is a huge issue. And we're going to talk about best practices for agents and brokerages who are using drone photography and videography. So let's jump in. Let's just start with the fact that drone photography and videography will continue to integrate into residential and commercial real estate marketing. It's already a big part of your marketing, and it's only going to increase as time goes on. So what do you need to know is something that hopefully you already do know, which is that there are federal, state, and municipal considerations with every commercial drone flight. When you hire a drone pilot or service provider to get that great photograph or video, or if you go do it yourself, you are conducting a commercial operation. So the FAA defines a commercial rather than a recreational drone flight as one that has any business purpose. A commercial drone flight is a flight that has any commercial value, which of course is going to be every single flight that occurs for real estate. what that means is you have to comply with federal law in order to put that drone in the air. The moment it takes off, there are licensing requirements and regulations that have to be complied with. Now, my guess is a lot of you may have already conducted drone flights yourself or hired people who may or may not have been FAA compliant. We are going to make the argument here that even though enforcement is low, the risk of getting caught is low, the consequences are really high if you are caught either doing the drone flight yourself as an unlicensed pilot or hiring a pilot who is not licensed, because you're going to be fully responsible for everything that occurs during that drone flight, and you can get fined just as easily by the FAA as the person hiring the drone pilot to do the flight. So the first thing that you need to know is Part 107 is part of the CFR under the FAA regs, which governs unmanned aerial systems, unmanned aerial vehicles, i.e. drones. So you need to be Part 107 certified in order to conduct a commercial drone flight. There's all kinds of requirements for certification. Got to be a certain age. You got to read, write in English. You got to be physically and mentally capable of conducting a safe operation. But most importantly, you have to take a test, an aeronautical knowledge exam, and then that gets graded. And then if you pass the test and you meet all the other requirements, you're then Part 107 certified. You can now conduct commercial drone operations. It's not an incredibly hard test, but it is aviation. They view you as a pilot. They view you as needing to be certified by the FAA in order to conduct flight operations. So you want to make sure that if you or anyone on your behalf or the homeowner's behalf is conducting a drone flight, that they have their Part 107 certificate, that you've seen the Part 107 certificate, that it's a valid Part 107 certificate. That pilot has to be able to present that certificate to anyone that may come to the scene. And that anyone is usually the neighbor calling the police because they see a drone out their window, and the police arriving on the scene. And at this point, police are fairly well versed in understanding that there is a certification requirement and that the pilot's going to need to be able to show their Part 107 certificate. All right, so that's a certificate that has to be renewed every 24 months. You have to be recertified every so often by the FAA. The person also has to have their drone registered with the FAA, and that is for recreational and commercial use, but you have to register your drone, which identifies that drone, to the owner of the drone, typically the pilot. And you're going to see here that there's great resources on the FAA's website that are available to you today that you can take a look at to be able to see how the FAA regulates drones. And so if you go to faa.gov.uas, you're going to see all the different information you need here. What type of flight is being conducted? For you guys, it's always going to be a commercial operation. So you could click on this link and it's going to take you to that page and tell you what's required for commercial operations. You're going to have to register your drone. And as we're going to talk about, you're going to want to have an app available to you so you can see what the airspace is for that particular property. So you want to be able to dig into this. You want to know about this. This is what I view for every real estate agent and broker. I mean, this is mission critical information. If you're going to be hiring drone pilots to get photography and videography, you better have a rudimentary understanding of what's required. And the number one thing that you need to be thinking about is FAA Part 107. And it's going to tell you about what's required for operations over people. It's going to have all the rules listed out. Here is a list of all the special waivers that you need if you want to engage in certain types of commercial flight activities. So for instance, if it's going to be a night operation, you have to have a specific waiver from the FAA to conduct that flight operation. If it's going to be from a moving vehicle, you have to have a special permission from the FAA. So these are really important things that you're going to want to have a base understanding of. All right. So Part 107, drone registration, those are standard. You also need to understand airspace. Yes, airspace. You need to understand where you can fly and where you cannot fly, because you're going to know where the property is. You're going to know where the property is located. If it's next to the airport, I will guarantee you, you cannot get drone photographs or video of that property because they do not allow drone operations near airports. Where they do allow drone operations is in what's called Class G airspace. And Class G airspace is, here's a good kind of basic map here. Class G airspace is going to be everything in yellow, and it's basically everything outside of cities. Well, that doesn't do you much good, right? If it's Class B airspace by busy airports, you're going to need a special waiver from the FAA. Your pilot's going to need a special waiver in order to conduct that operation, which they can get, but you need to make sure that they get it. If it's Class D airspace, you're going to be near smaller airports, easier to fly, easier to get permission. Class C, a little bit harder. So you need to understand airspace. The real problem with real estate and drones is most of the flight operations are occurring in cities where you oftentimes need special permission in addition to the Part 107 permission. You are liable and responsible for the drone pilot you hire. Yes, that's correct. The FAA can actually come after you as the principal hiring the agent to conduct the flight. You can even make the argument that the homeowner could be liable to the FAA if in fact you violate airspace rules. All right, should you do it yourself? I typically recommend you hire professionals for this type of thing. Yes, the neighbor kid owns a drone. Yes, you might own a drone, but this is a professional activity, and the professionals who know how to do it right, know how to comply, fully insured and all that stuff are the ones that you're gonna want to hire. All right, why should you care about any of this? Why should you care about hiring a FAA certified drone pilot? I do risk analysis. That's what I do as an attorney for companies, big and small. Again, the risk of getting caught, small. The consequences, if you do get caught, are large, right? So what are the penalties? You could get a warning letter. You can get a suspension or revocation of a certification, of a Part 107 certification if you happen to be a pilot. There are also civil penalties and fines and incarceration that could occur. And I will guarantee you, you put a drone up by an airport and an airline has to divert or can no longer take off, or a helicopter is in the area, the FAA will likely come after not only the pilot, but could also come after you and start to get into some of these civil penalties. There have been instances of up to $2 million worth of civil penalties for flights in cities. So it does happen. Failure to register your drone, $250,000 fine and or imprisonment up to 3 years. That would typically be for the pilot, but the similar penalties occur for flights that are not Part 107 certified. You know, the key here is that if you're a agent and regularly hiring drone pilots, you're going to be held to a higher standard of understanding the regulations, the certification requirements, and making sure that people you hire are compliant. All right. So I want to talk a little bit about negligence per se. Negligence per se is a legal principle which basically says if you violate a law, you know, negligence is a given, right? It's going to be, as a matter of law, you are negligent. So any drone operation, drone flight that occurs that was not FAA compliant, the attorneys are going to make the argument that it's negligence per se. So what can happen with a drone flight? Well, in addition to trespass or spying on the neighbor's daughter in the backyard or looking through a window, you have injuries. People have lost eyes, people have had lacerations. These types of things can occur. If you hire a drone pilot, that drone pilot loses control of the drone for their own fault or system failure, someone gets injured, and they're unlicensed, not only is it going to be a claim of negligence, but negligence per se, to which there's going to be very few defenses. All right. We talked about Part 107 and drone registration. We talked about the fact that you could also be liable, and that can also be criminal or civil. Now, your liability risk goes up the more drone flights that you have hired or conducted. If you happen to be Part 107 certified, you're going to be at a higher risk level for a criminal or civil penalty. All right, so let's talk a little bit about some of the kind of the legal principles that are going to apply here, that have been really well documented. You've probably seen in the press where drone pilots and operators have been accused of trespass because the drone flew over the property. Public nuisance is a big one, not only the noise, but the invasiveness. You do have invasion of privacy claims, civil claims that are being brought against pilots. And so there are these state laws that are being used in order to take what would otherwise be a lawful flight and create liability. So let's just assume you're fully FAA compliant, you've got all your waivers, the FAA is totally square with your flight operation. You conduct it, but the neighbor says the drone flew over their property and sues for trespass, public nuisance, invasion of privacy, etc. You could get drug into that lawsuit as the principal who hired the agent. In fact, you're going to probably be the deep pocket on that. Now, there are a lot of defenses, and I won't dig really deep into all of them, but you should be aware that there are a lot of defenses to any sort of state law claim that could be brought against you or your drone pilot under the federal field preemption defense. So, okay, fancy words. Let's talk about what that is. Certain federal laws and regulations need to be exclusive and preempt all state and municipal laws, because otherwise you're going to get a patchwork. It would be impossible for anyone to know how to comply. You can't have a patchwork of rules and regulations with regards to certain activities, because it just would stop commerce. Aviation is one of those activities where the Supreme Court has said, you know what, when it comes to aviation, we have to leave this to the Federal Aviation Authority. We need the FAA to be the exclusive rulemaker for aviation, because otherwise, how could a plane coming in and out of different airports ever know how to conduct their flight activity? Because the FAA says a drone is an aircraft, it's unmanned aircraft, but it's an aircraft, same principle applies. So federal field preemption should say, if all goes well, that these trespass, public nuisance, invasion of privacy claims should be dismissed as long as your flight is otherwise lawful. The problem is there's very few court cases and even fewer appellate court cases which deal with any of these issues. It'll take decades for there to be jurisprudence around this stuff. That just simply means for you guys, there's going to be risk, because you don't want to be the person footing the bill for the court case that has to go up to the Court of Appeals to figure out whether or not there has been an invasion of privacy because the drone flew past someone's bedroom window when they were getting dressed. All right. You do not want to be that test case. So those are the basics of the state and municipal laws and regulations, and how they interface with the federal FAA regulations. If you end up getting pulled into some sort of state law claim that's brought against you or your drone pilot, you're gonna want to push back hard with the field preemption argument right out of the gate. If you get pulled in on some sort of criminal charge as a result of a flight operation, which should be really rare, but has occurred as you get different prosecuting attorneys and police officers who hate drones, then you're certainly going to want to hire a lawyer and get a lawyer involved in that situation. Now, I just said something that I want to emphasize. In 2015, 2016, 2017, The general consensus is, I'm going to shoot down that drone. I don't like drones. I don't want drones that keep that drone away from me and my property. Don't point that drone camera at me. And if any drone comes near me or my property, I'm going to shoot it down, right? And that sentiment continues, although it continues to, it become less so as people get used to drones, but it's still a sentiment. So it not only exists between neighboring property owners sometimes, but it also exists within law enforcement. So there is a bias against drones in law enforcement. So sometimes you're coming up against police or prosecuting attorneys who don't understand how this is all supposed to work, but have this bias that they're bringing to the table. So you have to be really careful about that. All right, so how do you protect yourself? Okay, besides making sure that your pilots and service providers are Part 107 compliant, how is it that you are going to protect yourself in these situations? And really the best way is for you to understand the general principles involved here. Familiarize yourself with airspace and FAA regulations, and to get a written contract in place with whoever's conducting your drone services, because that contract is going to set expectations. If your drone provider says, well, I don't really have a contract, that's a red flag to me, because of the professional service providers, they do have contracts, and those contracts set forth and adjust the things that they are required to do, the licenses they're required to have, and set expectations for the flight operations. They indemnify you and warrant a number of things that are going to be important that they should warrant and indemnify, because they're the one conducting the flight operation. So if you're going to hire a company or a drone pilot to do a flight operation, the first thing I would say is, if you are, really doing this regularly, you should be able to identify the airspace of the home that you're going to fly, so that you know immediately if it's not Class G, if it's restricted airspace, if it's near a military base or an airport, you shouldn't even be hiring someone. And if you do hire someone, you're going to have to pay more, because they're going to have to go get waivers, which typically don't come very quickly, which means you're probably not going to have a flight that is occurring in that situation. So understand airspace, and I'll give you a link to an app that you can download onto your iPhone, and you can literally, anywhere you are, you can see what the airspace is, what the regulations are. It'll also allow you to put a pin on a map to be able to see where, that property, what is the airspace at that property. All right, so make sure your drone operator is properly certified. You need to check your drone operator's insurance coverage in the event of an accident. And there are really good insurance providers in the UAS space for drone pilots, including insurance on demand. So there are companies that drone pilots use where they literally go to the property, they log into the insurance company app, they say, I'm flying here today. The app knows what airspace it is, and it says, okay, we'll charge you a $10 for insurance for this flight operation. You get $1 million worth of coverage, or $500,000 worth of coverage. So it's on-demand insurance that these pilots are using when they get to the site. Some more sophisticated drone operators just have annual insurance that they sign up for that covers all flight operations. In either instance, you need to know and see the insurance coverage that's being provided for the flight operation in case there is a problem, and an injury or property damage and injury are the two big things that you're looking out for. All right, so when you're taking a look at this contract, you should see the warranties that say, I'm fully licensed. I warrant that the flight operation is going to be compliant with all federal, state, and local laws. And it's also going to deal with copyright issues. So let's transition here. Copyright is what protects photographs, video, and data. So the person your pilot, your drone service provider, owns the copyright to the images and the videos and the data. They're going to license typically you that data, photograph, or video for specific purposes. We'll talk a little bit more about that in a minute. The main point here is if your contracts don't have copyright license or assignment language in them, you're at significant risk of a copyright infringement violation lawsuit down the line. You, as the person who's using the photographs for your listing to put into the MLS, you're going to be responsible to establish that you have the proper license rights to do that. All right, and so we talked about making sure that you're getting indemnified against any problems from the flight operation. All right, that takes us right into copyright, and so let's just kind of take a step back. So what is copyright? Copyright is the intellectual property law that protects the author or artist or photographer who's creating the work, right? Whether it's a painting, whether it's a photograph, whether it's a video, the person who's holding the camera owns the copyright. They have the exclusive right to, and then fill in the blank, to use, to reproduce, to copy, to transform that work, that photograph or video. They can license you rights from those exclusive rights to be able to use the photograph and video in an MLS listing. For how long? For the duration of your listing agreement? For some other period of time? For a year? When does that copyright terminate? When does it expire? These are all going to be critical issues. How can you use the photos and videos? Most of these kind of low cost real estate drone operations, you're getting the right to use the video and the photograph in the MLS and hopefully on your website and potentially on your broker's website for the duration of the listing agreement, which means at the end of the listing agreement, it's got to come down, it's got to come out, you can no longer use it unless your contract says otherwise, right? So not only how can you use the photos and videos, for instance, if you got a personal website and you want to put these as example videos and photos on your website, you better make sure the contract gives you that license right. So generally, how long can you use it? For what purpose can you use it? And I'll show you a sample contract here in a bit that will kind of walk you through some of those license terms and what they look like. And hey, are your contracts covering these issues right now? I understand probably not, but they should. Drone services are professional services. You should have a professional contract for those drone services. All right, so we talked a little bit about copyright. We've talked a little bit about risk reduction and liability. We've hopefully convinced you that these things are important and that as you hire drone service providers and pilots, that you should be thinking about the contract, the pilot's licensing, insurance, copyright, some of these issues. Let's talk a little bit, and we talked about, by the way, what can happen in terms of FAA non-compliance and the penalties, civil and criminal, that can flow upstream to you. And we've talked about the neighboring property owner suing for trespass, for nuisance, for invasion of privacy, and how you could get roped into that. The other thing that we certainly all understand is that a drone can lose control and cause injury, lacerations, people lose their eyes, etc. Property damage, crashes into a window, crashes into a house, crashes into a car. You, unless you're indemnified, could be pulled in on that lawsuit, right? And certainly there have been 7-figure injuries that have been caused by drones, and you want to make sure there's insurance, and you want to make sure that you're indemnified against those types of losses. So let's talk a little bit about penalties for copyright infringement. So copyright infringement is pretty dramatic. So if you infringe someone's trademark, you pretend that you're Nike and you're not, big penalties for that. We all understand you can't go launch a business called Nike or pick some famous real estate brokerage and launch another brokerage using that same name. That's trademark. Copyright is anytime an original work of authorship is captured in a fixed media, fancy photographs and videos, right? Common law copyright attaches to the photos and videos and data, the photos and videos, the moment that it is captured in digital media. So common law copyright exists immediately. A photographer, a drone pilot, can register that photograph or video with the Copyright Office and get a copyright registration for the works, which is going to give them even more rights and even more damages if you should infringe. We have a whole system of copyright infringement trolls out there who are basically searching for photographs using various tools on the internet that allow you to put your photograph into this tool, and it will search the internet and see every place that that photograph exists. And these trolls and the attorneys who support them essentially take those photographs and videos and send threat letters to all the folks who happen to be using those photos and videos without a license or beyond the license that was granted. And then they ask for between $700 and $5,000, knowing it's going to cost a lot more than that to hire an attorney. Most people pay that because they have no choice. You don't want to end up on the receiving end of one of those particular threat letters. So what's going to happen if you end up exceeding your use rights for the photos or videos, or using someone's photos and videos that are beyond the copyright? And this applies to all the photos and videos you use, irrespective. And so this is fairly familiar ground, hopefully, for many of you. Damages can include a reasonable royalty. They're always going to at least include a reasonable royalty, meaning if you get caught infringing, you are going to owe that copyright owner whatever the market or whatever their reasonable royalty rate is for use of the photograph. So if you had it on your website for 3 years, what would that normally cost, that 3-year use? You're going to be liable for that. If the photograph or video are registered, which is the exception rather than the rule, but if it is registered, then you could be on the hook for statutory damages, which could be up to $150,000 per infringement. Also, if registered, you could be on the hook for attorney's fees, and whether registered or unregistered, you could be on the hook for equitable relief. Usually that's an injunctive type remedy where they're asking the court to order that you remove and cease and desist use of the photos and videos. So these are all things that you want to be aware of for copyright issues. Again, I'm pretty certain you guys are familiar with this type of thing because you live in a world of photographs and videos for your properties. Drones are just another method to get those videos and photographs. All right, so let's talk a little bit about best practice for agents and brokerages who are looking to hire pilots and use drone photographs and videos on the MLS or otherwise, right? So best practices are going to be, and these are my recommendations, are going to be as follows. Seek out a professional service provider. The market is moving from, hey, I asked the kid who bought a drone, who lives next door to me, to go take these drone videos or photographs. We're moving away from that. If your brokerage or agency has a preferred drone service provider, that's great. You still should make sure it's the right drone service provider that's fully licensed and insured. Make sure that you enter into a written contract, and I'll show you a sample contract here in a minute. Understand your copyright license rights, very important. Make sure that those are spelled out in the contract. Review the policies and best practices from your agency or brokerage, right? Certainly many of the brokerages understand that there's potential liability. Some of them have policies in place for the agents that they have to comply with before taking drone photographs. That's a good thing. You should have those that apply across the board for all of the folks at your agency or brokerage. You want to make sure that you are developing checklists that will be used for drone operations, and following those checklists as you bring new people in and out of your team, right? Which is in your world can be a bit of a revolving door. So make sure no one underneath you is making a error that's going to create liability or risk for you. Also become a knowledgeable real estate agent regarding drone photography. Understand that there are regulations, understand that there are consequences in the unusual circumstance where something goes wrong, because that knowledge is going to give you a leg up on the competition. Now, how do people end up getting in trouble? Oftentimes it's because another real estate agent or another drone operator reports an illegal flight operation. So if I'm a professional service provider in a town providing drone photography to real estate agents, and I see that someone over here is getting paid, maybe undercutting my price to be able to conduct that drone flight, I have a high incentive to call the field office, the FAA field office, or the police and report that drone flight as illegal. So even though there aren't a lot of field officers, FAA field officers out there, watching what's going on, there is a very high chance that a competitor is going to get upset if they're being undercut in price because some fly-by-night operation is doing these flights and taking these photographs. So that's probably the number one way that people get in trouble, being reported by a competitor. The other way is if there's an incident. If there is an incident, the drone pilot actually has to report that upstream to the FAA field office, and there will be an investigation. So property damage or personal injury are automatically going to trigger an investigation. That investigation is going to find its way to you and the contract that you had with the pilot or the service provider. All right, let's talk a little bit about the Before You Fly mobile app. This I recommend all real estate agents should have have that particular app on your phone, because you can go to whatever property you're listing and take a look at the airspace and see if that property is going to be eligible for drone photography and videography. You can get the Before You Fly app in the App Store or for Android, no problem. And it's going to tell you all the rules of the road. It's going to tell you the airspace. It's going to tell you what would be required of your drone pilot before they conduct that flight operation. All that good stuff, right? So standard operating procedure for any real estate agent, in my opinion. All right, so let's take a look at, real quick here, pull this up, a SUAS service agreement. And this is essentially a contract. This should be similar to the contract that you're seeing from your drone flight crew, from your pilot or your service provider. Now, pilot, I usually refer to as a pilot as, just a single operator who's going out and conducting flight operations for real estate folks. A service provider is more of a substantive company that's got multiple pilots or more of a formal structure to it. And under either circumstance, they should have some sort of agreement, which is going to have information about what services are going to be being provided, FAA regulatory compliance and reporting. What are they going to do? Get video, get photographs, how many, how much? Are they going to do any post-production work on it? What is the fee that they're going to charge? A half day, full day, flat rate? And what are the deliverables? The deliverables are going to be, is it going to be 10 photographs? Are they going to be produced photographs? Is it going to be X number of minutes of video? This basic information should be in there. The service date should be in there as well. If they can't fly because the weather's not great, there should be alternative service dates. What are the payment terms? What is the insurance? What is the compliance? And then intellectual property is going to be covered in the copyright, which you'll see in a minute, the copyright license agreement, what warranties and limitations apply, governing law, personal jurisdiction, you're familiar with all that stuff. And then a copyright license agreement. Okay, copyright protected works include the photos and the videos. This is an exclusive. It's typically going to be a non-exclusive license. If you want to buy an exclusive, they typically charge more. Can you assign your rights? Yes or no? What's the scope of use? Can you incorporate it into some other work? If you wanted to do a flyer and put that photograph in as one of the photographs, that would be incorporating the work into that flyer. You need those rights. Can you reproduce that work? Can you make copies, digital or otherwise, of that work, derivatives? So can you distribute it? Can you make modifications? These are all the bundle of rights around copyright, which you should be familiar with. And how can you use it? How can you not use it? All right. So these basic copyright licensing information that you should get nailed down. The other thing I will just conclude with is this: you are not required to get permission from neighboring property owners in order to conduct flight operations, but it's a good idea. And so, you know, the good drone service providers have like a notice of UAV operations form. They'll put it in the mailbox. They'll give it to the neighboring property owners just to let them know on this date and time, we're going to be conducting a drone flight for the purpose of marketing this real estate to put in the MLS. We will not capture any person from your property. We will not, look in your windows. If you have any questions, call this name and number, which is the drone pilot. By setting expectations, you take away from the surprise. People who see a drone out their window who didn't know that drone was going to be there have a completely different reaction than, hey, they were told 2 days ago that there'd be a drone flight. There's the drone. Now all of a sudden, maybe it's interesting. Maybe they want to go out in the street and see the flight operation. And maybe they even want to hire that drone pilot to take amazing photographs and videos of their property as well. All right. My name is Enrico Schaefer. I'm an attorney with Traverse Legal and Drone Law Pro. Drone Law Pro is our website that is related specifically to drones. Traverse Legal is my law firm. You can find information about me on the web, traverselegal.com or dronelaw.pro, and always happy to help. With that, I will turn this back over and stop sharing my screen. And there you go, Greg.
Enrique, that was outstanding. That was one of the best presentations I have ever seen. Everyone who heard that, they're lucky to have heard it. And I wouldn't be surprised if your phone and your email are ringing off the hook as soon as people see this Con Ed. So thanks a lot. That was absolutely outstanding. That's the end of our presentation for today. Thank you.